raise the issue of the age of the minor. I would also consider the mitigation that he gave, and I will also still consider his age.
Okay, in your submission, among the things you have asked the court to consider,
Yes.
is that the complainant, that is a 15-year-old girl,
Yes.
the complainant admits having been friends with the appellant and went to meet him on her own volition. And then part 4, the complainant, that is now the 15-year-old girl, having not contracted any disease or fallen pregnant, but was able to proceed with her education. Why do you think those two issues that I've read out, the court should consider those two issues?
Yes, the impact of the offense on the victim.
Yeah, but you know, this one you're asking the court to consider to reduce the sentence for the accused, the accused person, the convicted person. Why is it necessary for you to consider not the victim,
Yes,
but in terms of reviewing sentence?
the impact on the life of the victim is important.
But here you
Yes.
have asked the court to consider these two issues. There are 4, but of particular concern are these 2
Yes.
in reducing the sentence of the convicted person.
Because they were not considered in the trial court.
Why is it necessary to consider
Yes.
that a person was not did not fall pregnant, neither did they contract a disease as a mitigating factor before sentencing? Why is it important to you? Because that is what you have put in your submissions for review of sentence.
My consideration was the fact that the victim will somehow be able to salvage their life, and it's not totally lost, as opposed to the harsh sentence that was handed to the accused person by the trial court.
Okay. It is said that the Kenyan judiciary is not pro-poor, and the Constitution requires all of us to promote equality.
Yes.
And Bangalore principle of judicial conduct equality is among the principles.
Yes.
So in interpreting the law, how are you going to ensure that you inculcate the principle of equality in your decisions?
By making decisions that cater for the social and economic circumstances of litigants appearing before me, by considering their cultural background and age, their gender, and even their economic status.
Okay, thank you, Chair.
Thank you, Chair. And welcome again, Agnes.
Yes.
Would you share with us how does the judiciary contribute to the national development goals of this country? Very briefly.
Yes, a strong judiciary guarantees, or rather ensures, a strong economic situation of a country. If investors are confident that they can do business in this country, and where disputes arise, particularly in contract or even in their investments, that they're going to get a fair and reasonable decisions, then it puts ahead our economic situation. The judiciary also has come up with other alternative dispute resolution forums like mediation, which ensure that disputes are resolved within the shortest time possible, and that makes for a strong economy of a country, and people are able to do thriving business. the judiciary also promotes the Constitution. And in a country where the Constitution is promoted or given strength, then the economy of that country will definitely thrive. Yes. Yes.
Okay. My second and last question is that you explain the role of the judge today,
Yes.
How it has changed from that of a traditional judge as we have always known it.
Thank you. The judge today has an obligation to developing the law and promoting the Constitution. The role of the judge today is not just as an arbiter
I
of
want to hear what has changed.
Yes. The role of the judge has now, there has been realized the need for empathy, and the judge is now recognized as a strong pillar of society and even the economy of the country.
Is there any role that that ICT plays in the role of a judge?
Yes, yes. ICT ensures that there is faster delivery of justice, and that there is easy access to justice, because decisions are easily available and the court system is readily available.
Thank you. Commissioner Rand.
Thank you, Chair. Good morning once again.
Good morning.
Okay, if you're successful to join the bench as a judge, you will find occasionally you will encounter advocates who, for lack of a better word, I'll describe as cantankerous. You know, those who come and they do not want to listen. They want to take charge of your court. They want to direct how you're going to conduct proceedings there. How do you purpose to deal with such advocates, or even parties for that matter?
Thank you, Commissioner. I will first and foremost ensure that I conduct myself with decorum, because what you give is what you get in return, although sometimes it doesn't exactly work that way. I would take up measures by ensuring that if an advocate is, I will take up measures to ensure I have full control of my courtroom. I will not give room for people to express their private or their personal side in my courtroom.
Those measures?
I would make use of the court bailiffs and other staff to make sure there is order in the courtroom, and I will constantly make reminders that of the need for decorum in the court, so that we can move towards a speedy resolution of disputes. I would make use of the court users committee to sensitize advocates, particularly, and even litigants, on the importance of maintaining decorum in court.
You will not have difficulty stamping your authority and taking charge of your court. You don't see yourself having difficulty achieving
I will
that?
not. I will not.
Okay.
I will not.
Okay. The second question I have for you, you are currently operating your own law firm.
Yes.
How many associates do you have?
Currently, I do not have any associates in my law firm.
Okay.
Yes.
And just giving a rough estimate, what is your workload like?
In terms of litigation,
Yeah,
I
the cases
am-
you have. Or,
yes,
yes.
I am in court at least 3 to 4 times in a week on either applications or full hearings. I have
Roughly,
mentions.
like how many cases you have, the nature of clients you majorly
Yes.
attend to. Yes, that's what I want to hear.
I mostly deal with individual clients one-on-one, not
Mhm.
as opposed to corporate clients.
Mhm.
I have a big portfolio. I lost count at some point. And my law firm has grown from clients referring other clients. I can say with confidence that at least every client I worked for has brought back at least one other client, and that is how my law firm has grown.
Okay.
Yes.
Do you have a performance measurement framework in your law firm?
On myself, I have targets.
You are not alone in the law firm, are you?
No, in terms of
I assume-
advocates,
yes.
I am the only advocate in the law
But you
firm.
have other staff.
Yes, I have a secretary who also serves as a receptionist. I have a court clerk. The measure for my performance is actually something that I do according to my targets. As for the staff, I gauge their performance, and where there is need, I call them and have a talk with them on how
What do
the
you use
areas
to
improve.
gauge? You just look at how they perform. Are there instruments you use?
First of all, I believe in discipline. I'm a strong upholder of discipline and timeliness. I believe that if you're not able to keep your time, I think you may have challenges performing your work to required standards, because then if you, like, for example, you come into the office at 9 and you're required to be elsewhere at 9, you're not performing. For me, it's on a day-to-day basis. Yes.
Okay, now, before we embarked on this exercise, we
Yes.
engaged some of our stakeholders
Yes.
just to get a feel of what they want
Yes.
in the kind of judges we are to recruit.
Yes.
One attribute that featured strongly was that they needed someone who's a hard worker.
Yes.
So now what would you use to persuade this commission
Yes.
that you are a hard worker?
I have submitted testimonials, which are mostly from people that I have worked with. But on myself, I diligently perform work that is given to me by clients, and that explains the natural growth of my law firm. Like, I have not had to go soliciting for work or such like things. I believe in delivery. I believe in substance and delivery of substance. Yes.
Okay. Now, lastly for me, under Order 11,
Yes.
we have the case management conference.
Yes.
At the end of that conference, that procedure, can you give us 3 kinds of orders you are likely to issue as a judge?
I can request parties to amend their pleadings if their pleadings are not proper.
More like the final orders you will be making at the end.
At the
You
end,
see, when they amend, you're still at the stage of pretrial, isn't it?
very
Then
well.
you still look into those amended pleadings. I'm talking about at the end of the exercise, the case management exercise, 3 orders you're likely to give.
Certify the matter ready for trial, give a hearing date, or give directions as to speedy prosecution of the matter. Like, for instance, can we dispose of this matter by way of written submissions?
Okay, that's not what I was looking for, but yes. Any other?
At the end of pretrial, I might as well, I might also require for, that is discovery and all that has been done.
That's what you do in the pretrial.
Yes.
Yes.
I might refer the matter to, I might decide my court does not have jurisdiction.
Okay, thank you.
Yes.
Thank you, my lady.
Commissioner Excellency Ruto. Thank you very much, CJ. Now, can you tell us the guiding principles of leadership
Thank you, Honorable
and
Commissioner.
integrity?
Sorry?
Leadership and integrity.
Diligence, efficiency, timeliness,
Specifically as in chapter 6.
competence, integrity, honesty.
Okay, and now in leadership, what would you consider as transformational leadership style? And are you one such person?
What I will consider my transformational, please say again.
Would you consider yourself as a transformational leader?
Yes,
Can you
Yes.
explain?
because I am a person who likes to see progress in society, and I have a keen sense of responsibility. I always take charge of my civic duty. Like for instance, I will participate in every general election, the Law Society elections, or any other forum where I'm required to exercise my civic duty. I participate in community development. I help the less able members of society, not just by giving them money, but considering the fact that I'm a lawyer and I have come across quite some experience and knowledge, I am able to volunteer to render advice to members of society, even when there is nothing to be gained from it. Yes.
Thank you, CJ.
Thank you, Honorable CJ. Good afternoon, good morning, Honorable Ms. Agnes.
Good morning, Honorable Commissioner.
Okay. As a follow-up question from what Commissioner Ruto has asked, maybe you could tell us what integrity means to you.
A person of integrity is a person who is not likely to be swayed by selfish or self-persuasions, who will deal with given set of circumstances, regardless of whether the outcome favors them. In a sum, to say a transparent person. Transparency.
Would you consider yourself, or would you term yourself as a person of integrity?
Yes, I am.
Okay.
Yes.
The question about guiding principles of leadership and integrity, maybe you will need to go back and refresh yourself on those ones.
Thank you.
Please tell this commission, have you ever come into any conflict with the law in the past?
At a personal level?
At a personal level, yes?
No.
You've never come into conflict with the law?
No.
Any other way?
Not that I can think of. No.
Okay. As we do background vetting for candidates, we work with different agencies, different government agencies, to provide us with reports, and you're also expected to do that. Have you cleared with the different government agencies that we work with?
Yes.
Have you encountered any issue?
No.
Okay. My other question to you would be regarding corruption in the institution. Judiciary is seen to be a weak link in the fight against corruption. What is your view on that?
As much I will say there is room for improvement, I know for a fact that the judiciary has really evolved from what it was before, and we as advocates actually feel the effects. The levels of corruption have drastically reduced, and I believe it's a work in progress. Yes.
If you're successful and you become a judge, what are some of the measures you're going to put in place to ensure that these incidences are eliminated or reduced?
Incidences of corruption.
Corruption in the institution.
I will start by sensitizing stakeholders, and that is court users, the subordinate staff, and my colleagues even on the vision of the judiciary that it has to. We are undergoing a transformation, and we cannot be accused of corruption anymore. We need to move forward from that.
So sensitization is the only way? Any other way?
Myself, I would make sure that the system is foolproof, particularly in the station that I'm handling. I will make sure that all the systems are transparent in the way that leaves no room for corruption.
How do you do that?
I am used to taking charge, at my practice, I am used to taking charge of each and every work that goes on, and I would really supervise in a way that anybody who might be tempted that way feels challenged. I sensitize people regularly that, you always be honest even when one is looking. Apart from sensitizing and then putting systems in place, I would ensure that myself, the way I handle myself, leaves no doubt that I am beyond, yes, I am beyond corruption. And I, in the hope that that might inspire others to follow.
Okay, thank
Yes.
you. My final question, as a leader and as a judge, if you're successful, how are you going to advocate for diversity and inclusivity in the institution?
Again, I will use the word sensitization, and by sensitizing the community or even the people around me on the importance of supporting each other regardless of your age, your gender, because I believe that whether man or woman, it is only if we support each other that we can go forward. I also, by encouraging or supporting the weaker members of the society that we are living in.
Okay.
Yes.
Any
And,
other?
also information, giving information, really.
Why do you think it's important to advocate for diversity and promote diversity and inclusivity?
Because I believe that everybody has something to contribute, even the weakest member of our society.
Any other reason?
And it's also because our Constitution, it is my duty under the Constitution to uphold diversity.
Okay.
Yes.
Thank you, Honorable CJ, and I wish you all the best.
Thank you.
Thank you very much, Ms. Joroge, for availing yourself for this interview. I think this brings us to the end of the interview. We will contact you when we complete the exercise. But before we release you, we always give a candidate an opportunity to ask us a question if you have any.
Thank you, Honorable Commissioner, Madam CJ. I do not have any question, but I'll take this opportunity to thank you all for having me and engaging with me. And I also wish you the best as you look for the right candidates to steer our judiciary ahead. Thank you.
Thank you, and keep up the good work that you are doing in private practice, representing clients in our courts.
Thank you.
All the best. We'll get in touch with you.
Thank you.
Jacqueline Ngutia, Commissioner, welcome.
Thank you, Commissioner. Good morning. My name is Justice Mohammed Ibrahim, Supreme Court Commissioner.
Thank you, my lord.
Good morning.
Good morning, my lady. opportunity to attend specialized courts like the Environmental and Land Court, the Employment and Labor Relations Court, and also I have matters before the High Court. The bulk of the matters are under the Commercial Court, the Civil Court, and the family-related matters, my lady. I've also appeared before the Chief Magistrate Court and also including the Small Claims Court, my lady.
Thank you for that. And what are your attributes? If we were to ask you, what do you bring on board if you were to be the successful candidate?
My lady, by virtue of the kind of litigation that we handle, I would first point out that the key achievement that I've been able to bring about is a contribution to jurisprudence. If you were to look at my CV, my lady, there are a total of about 30 reported cases. Right from the year 2017, there could be more, but I constrained myself to the period of year 2017. So I have contributed to the jurisprudence in not only in commercial, but also land matters and also the civil matters, my lady. And the key attribute I'll be bringing, my lady, is I will be bringing efficiency. Why do I talk about efficiency? You do realize that as a practicing advocate, that the tool I have been using is Order 11 in terms of ensuring compliance in all of my matters. And you, once you're compliant in terms of filing your, for example, your witness statements and documents, you're actually ready to proceed with your matters. And that, my lady, has contributed to me actually concluding matters at a very high rate.
So you bring efficiency?
Yes, my lady.
Anything else that you bring on board?
I would find myself as a team leader. Currently, I work in a supervisory role. I have court assistants and also have pupils who are working under my lead. And I'm able to, and I'm glad to report that since I was given this role in the year 2020, I have been able, there are 2 advocates who have been able to mentor and currently are practicing and actually practicing well, my lady.
Very well. And finally from me, of course, having been an advocate from the year 2008 and practiced in our courts.
Yes, my lady.
I'm sure there are certain attributes that you see amongst the judges or judicial officers that you think that if I become a judge, I am not going to be like Mr. or Miss X.
Yes,
what
my
are
lady.
Those?
My lady, my concern would be on perhaps on a competency level, because you notice that some of the judgments and rulings that are churned from some of our courts do not really articulate the issues that have been raised by the parties. So if I were to become a judge and given that opportunity, my desire would be that I would be able to churn qualitative and quantitative judgments. Then too, my lady, I have seen some magistrates or judges who are temperamental. They're not really keen to hear the sides of the parties and they're quick to make decisions. And my lady, in that front, if I were to be given an opportunity, I would desire to have a listening ear, to listen to everyone's views before making proper directions in the matter, my lady.
Thank you. I want to clarify, which area of law did you say is your strength?
I have a lot, my lady. I have commercial, I have civil, and I have family-related matters, and employment matters, and also land matters, my lady. And also, yes, my lady.
Yes. Under the Constitution.
Yes, my lady.
Just tell us which orders can be issued if one were to file a case seeking the determination of fundamental rights.
My lady, I would be guided by Article 23 of the Constitution, and we have various reliefs under that that article. That would be the order of injunctions. Would be able to issue conservatory orders, an order for compensation, an order for habeas corpus, and a declaration declaring a law perhaps invalid, and declaration of rights. And one that is not purely stated is statutory interdicts, as guided by the Mitubel case.
Yes, and what circumstances do you issue statutory interdicts?
My lady, I believe it is instances where you're giving supervisory orders, especially, for example, where the government has breached certain articles in the Constitution. So, my lady, the court will actually be giving directions in terms of, number one, articulating the kind of breach that has been occasioned by the government, how that breach can be rectified, and my lady would be also giving an action plan on what needs to be done so that that breach can be rectified, my lady.
Okay. The next set of questions will be asked by Justice Majanji.
Good morning.
Good morning, my lord.
I heard you speaking that you are very efficient in handling cases and you rely on Order 11. But in one of the cases you cite, the case was actually dismissed for want of prosecution. What went wrong?
My lady, this is a matter that actually was given to me a few days. It was actually been handled by another advocate. But then again, I would not want to lay blame on that. I think as a firm, we did not utilize the bring-up system too well, because had we done what we were supposed to do, that matter, my lord, would not have been dismissed. It was a bit of negligence on our part,
Well,
I must admit.
Secondly, I've looked at your CV, and on pro bono activities, you say, regrettably, I have been unable to commit to pro bono activities as my availability for such activities is contingent upon discretion of my employer, which has limited my ability to participate.
Yes, my lord.
So, for the 15 years you've been practicing, you have not been involved in any pro bono activities?
Unfortunately, Lord, not my lord.
Have you had, like, for example, I'm sure you go to church?
Yes, my lord.
And you don't involve yourself in pro bono activities?
Or
what do you understand by pro bono activities?
I think my understanding, of course, is that you're giving free legal advice to those who are unable to, get that service.
Is it limited to free legal advice?
I think when I was answering that question, my lord, I was a bit narrow-minded. But of course, in church, you would have members who actually come and seek for legal advice. But I did not think in that aspect. Yes.
And as a judge, why do you think it's important that you, why do you think we emphasize pro bono activities for this position? Why do you think it's important?
My lord, it is important because everyone has a right to access justice, as guided by Article 48 of the Constitution, and also as guided by Article 159, where everyone is supposed to access justice, regardless of status, my lord.
Okay. Finally, you've heard of the Small Claims Court.
Yes, my lord.
It's an important door to justice.
Yes, my lord.
Can you just tell us some of the controversial decisions that have been made in regard to that court?
I think I will point out one that is most recent, my lord, where the court stated that it does not, that the Small Claims Court does not have jurisdiction to handle what you call personal injury claims. My lord, the reasoning behind that judgment was that based on two issues. One is the aspect of service of notice under Section 10, subsection 2 of Cap 4.5, and also the aspect of general damages you cannot quantify.
And so what is your view? My
view is I am not really in agreement with that, because there's a reason why that statute provides that that court can hear personal injury claims. My lord, if you were to look at the nature of personal injury claims, for example, soft tissue injuries, I am yet to come across a judgment that is beyond 1 million, because when you look at the pecuniary jurisdiction, it is not more than 1 million.
That's good enough. Finally, as a High Court judge, how would you support the Small Claims Court? How would you support the Small Claims Court?
You notice that the small claim courts usually have a limited number of days within which to conclude their matters. So, my lord, if at all there are matters that emanate from the Small Claims Court on appeal level, then it will actually be befitting if one is able to conclude their matters in the shortest time possible, to give meaning and effect to the Small Claims Court Act.
Okay, thank you. Thank you very much.
Thank you, my lord. Thank you, my lord.
Now, I've read your sample writings.
Yes, my lord.
Sorry, thank you. I've read your sample writings. They're very concise. And when you were, most of them is where you're acting for parties, I've seen. for the respondent, for the petitioners, and so on, you are speaking to the judge or the magistrate, the judicial officer. But now as a judge, how do you think you would like or you intend to present your rulings of judgments? How do you structure your judgment, for instance?
Okay, first of all, I would start by setting out the issues that have been laid out in the various pleadings. For instance, for example, I'll start, for example, with the plaintiff's case, then the defendant's case. I'll be able to bring out the factual issues and what exactly is the cause of action. Then upon doing that, my lord, I would be able to analyze, of course, the facts in tandem with what the law provides and be able to make a informed conclusion and do a balanced effect on the outcome.
After giving the background, and